Joking aside, we're really happy that you're here. My name's Tom Linney. I'm the pro bono director of the Animal Legal Defense Fund. It's my honor to moderate this panel today, which is We Can See You, Legal Strategies to Increase Industry Transparency and Accountability. You can read more about our panelists' impressive bios online. I won't go through them all because we would do half the session with that. But our first panelist is Matthew Liebman. He's the director of the Animal Legal Defense Fund's litigation program. And really his work touches on all of ALDF's civil cases. He's litigated cases including the first successful challenge of the ag-gag law, the rescuing of a captive bear. Yeah, it's a big one. The rescuing of a captive bear from a concrete cage where she languished for 16 years. And helped rescue 100 dogs from a North Carolina hoarder, in addition to a ton of other cases in his long career at ALDF. He's also, his writings appeared in the Animal Law Review, the Journal of Animal Law, the Stanford Environmental Law Journal, the Animal Legal and Historical Web Center, and he's also the co-author of a worldview of animal law. In the spirit of this panel on transparency, we thought it might be a little fun to be transparent about our panelists and some of their guilty pleasures outside of animal law. So for Matthew, he has a soft spot for really terrible horror movies, which we recently watched Invasion of the Animal People. So look it up. I'm sure I won't. Our next panelist is Laura Hagen. She serves as counsel for captive animal law enforcement for the PETA Foundation, where she provides legal advice and assistance on a wide range of issues on behalf of captive wildlife, including investigations, regulatory efforts, policy work, working with law enforcement, and assistance with litigation matters. She was formerly with the Massachusetts Society for the Prevention of Cruelty to Animals, where she managed advocacy campaigns, largely focusing on legislative and regulatory initiatives impacting wildlife, and this included trafficking in ivory, rhino horn, and shark fins, and defending its efforts to expand trapping and hunting domestic wild animals. Her impressive portfolio also includes a successful ballot question prohibiting intensive confinement of certain farmed animals. And going back to our theme of transparency, Laura's guilty pleasure is watching the Real Housewives TV series, and something tells me she's not the only person in the room that shares that. Our final panelist is Michelle Welch. She's the Senior Assistant Attorney General in the Virginia AG's office. She's the director of the Animal Law Unit at the AG's office as well. She's called on by agencies all over the Commonwealth to act as a special prosecutor in animal cruelty and animal fighting cases. She frequently gives advice to law enforcement authorities and prosecutors all over Virginia, the nation, and internationally, which I thought was interesting. She's trained the Greek police force and Greek prosecutors and judges on animal cruelty crimes, and she's even spoke before members of the United Kingdom Parliament on dogfighting. So maybe she can talk to us about the royal wedding later. And you may be surprised to learn that she's a huge comic book fan and was a big fan of the recent Justice League movie, which scored a lowly 40% on Rotten Tomatoes. For those of you keeping score at home, we won't judge her for that. But Matthew's going to start us off, and please join me in welcoming our panelists this morning.
Thanks, Tom. And thanks to all of you for coming. So I want to start us off with see if I can get this working here. Yeah. Thanks. All right, so I want to start us off with a simple Buddhist saying popularized by a monk named Ajahn Sumedho. Right now, it's like this. And this is a saying that has a certain way of centering a mind that's in the grip of anxiety, worry, fear, catastrophizing. Right now, it's like this. And the saying has two important components. First, it orients us towards whatever is dwelling in our minds at the moment. It orients us to the present moment. We don't have to like it. We don't have to accept that it's the way that things ought to be, but we do have to acknowledge and reckon with, as a factual matter, that it is the way that things are right now. And by understanding the complexities of the current moment, perhaps we can start to think through new ways of engaging it and ultimately new ways of changing it. And that's the second important part of right now. It's like this. Right now, it's like this, but it doesn't have to be, and it won't be. The future can be different, and invariably the future will be different. And whether it's better or whether it's worse, in large part depends on our ability to reckon with things as they are right now. And so if we're envisioning a world in which the lives and interests of animals are respected by the legal system, if we're envisioning a world in which people think twice about sacrificing animals' lives for food, we have to start right here. Right now, it's like this. And Joyce and Susie did a terrific job of showing us what it's like right now for animals on factory farms, how horrific their lives can be. And the next step is to get that message out to the public in the hopes that they will realize for themselves that right now it's like this for farmed animals. And that's why we, as a movement, view transparency as a tool for social change. There's a social scientist named Timothy Pacharat, who Susie actually just mentioned, a terrific book called Every 12 Seconds, Industrialized Slaughter and the Politics of Sight, which I recommend everybody pick up if you're not familiar with it. He defines the politics of sight as an organized, concerted attempt to make visible what is hidden and to breach, literally and figuratively, zones of confinement in order to bring about social and political transformation. And that's really what transparency is about. The zones of confinement that we're talking about are these places where animals' lives are hidden, where their abuse is hidden, factory farms and slaughterhouses. And so if we can bring light to these hidden zones of confinement, we can hopefully transform society. We can encourage people to change their behavior individually and collectively. And in fact, surveys bear this out. There's a survey by the U.S. Farmers and Ranchers Alliance that found that 70% of consumers said their purchasing decisions were affected by how food was produced. Another survey by Label Insight found that 97% of consumers said that transparency is either very important or somewhat important for their dairy products. 96% said the same about meat products. And so this is an issue that consumers care about. The issue is how do we get the message out there. Another study from the Kansas State University of Agricultural Economics found that as a whole, media attention to animal welfare, and that's really a large piece of what we're talking about when we're talking about transparency, ultimately has a significant negative effect on U.S. meat demand. And so the more we can bring these issues into the popular conversation, the more we can affect purchasing habits and the fewer animals ideally are killed. And so one of the ways that we work on this issue is through litigation. As the director of litigation at the Animal Legal Defense Fund, we try to increase transparency in the ag industry through lawsuits. And I'm going to talk about three ways in which we do this. The first is ag-gag laws, the second is Freedom of Information Act, and the third is false and misleading advertising. But before I get into that, I want to acknowledge my team. I certainly don't do this work by myself. I don't even do most of it. I just oversee great people who do it. And so if you're here and on the litigation team, please raise your hand. Christina Stella does amazing work. Who else? Amanda Howell, Lexi Monson, Tyler Lobdell, Sarah Hannikin, Tony Ellis Susan, Matthew Strugard's here, not on our team, but has worked on the ag-gag cases and done terrific work. So I definitely want to acknowledge everyone's work. Some of the cases I'm talking about will be Chris Berry. I'm sure I've forgotten someone under these lights, but everyone on our team is incredibly important, and I don't want to take credit for their work. So let's jump into it. Our ag-gag work is obviously one of the most significant ways in which we try to increase transparency. The only way that the public sees what happens on factory farms is through the work of undercover investigators. And almost all of the pictures that you'll see today that are inside facilities come from undercover employment-based investigations, where investigators go in, get a job, wear a hidden camera, and expose the truth about how animals are treated. So this, to me, is really the cornerstone of how lawyers and litigators can use the law to protect the social movement that is trying to shine a light on these zones of confinement. And ag-gag laws are statutes that criminalize or create civil liability for undercover investigators who go undercover at these facilities. And you've, I'm sure, seen these investigations. There have been more than 100 of them in the last 15 years or so. The Animal Legal Defense Fund has conducted a few of them, one at a Tyson facility, a slaughterhouse for chickens in Texas, that showed horrific treatment. These investigations show not only abuse of animals by individual workers, but much more significantly, they show abuse that is systematic, abuse that's routine, things that are standard industry practice, and things that are inherent in the production of animal products. And so these investigations are not only about identifying bad apples at these facilities who are kicking a pig, they're about exposing the entire system. And so that's what our investigations have tried to do, is to show that where there are failures of systems, animals suffer. This is an investigation we did at a Hormel supplier in Nebraska, in which the automatic feeders ran out of food and weren't refilled for several days. So these investigations are incredibly important to show the truth of how animals live their lives. There are 9 states that have passed ag-gag laws. Chronologically, they're Kansas, North Dakota, Montana, Iowa, Utah, Missouri, Idaho, North Carolina, and Arkansas. There are 3 types of ag-gag provisions. They go about trying to shut down undercover investigations in 1, sometimes 2 of 3 different ways. The first are direct bans on photography and videography. So some of these just say you cannot take a picture or a video at a factory farm without the express consent of the owner. Those are the classic ag-gag laws. The second type are prohibitions on access by false pretenses. So these statutes will, instead of just saying you can't take a picture, they'll say you can't lie on an employment application or hide the fact that you work for People for the Ethical Treatment of Animals, or hide the fact that you're a journalist when you're applying. And so if you go in undercover and you don't disclose, hey, I'm here to expose the horrors of your factory farm, then you violated the ag-gag law. And the third version, and there's only one of these that's passed, that's Missouri, is a mandatory reporting statute. And these require anyone who documents animal cruelty at a factory farm to turn over the footage to law enforcement within 24 hours. And on its face, that sounds good, right? We should all report animal cruelty when we see it. If you see something, you should say something. But in fact, these are obviously, if you look a little more closely, designed to out undercover investigators before they have the opportunity to conduct their investigation. So if you're in a state like Missouri, on a rural factory farm, and after your first day of your investigation, you have to go tell the local police officer, who's probably went to high school with the guy that runs the factory farm, hey, I'm doing an undercover investigation here, here's my footage, you're probably not going to go back on day 2 for fear of your life. So these mandatory reporting statutes, although they look good on their face, are actually targeted at stopping undercover investigations before they have the opportunity to develop. And undercover investigations take weeks to unfold, especially if we're talking about systems and not individuals. So if we're talking about exposing the complicity of management, if we're talking about showing practices that are routine, that are common, that aren't just isolated incidents, an investigation has to unfold over more than 24 hours. So these are the 3 types of ag-gag laws. We filed lawsuits challenging 4 of them so far: Utah, Idaho, North Carolina, and Iowa. And our arguments primarily rely on the free speech clause of the First Amendment to the Constitution, essentially arguing that the whole purpose of these statutes is to silence half of the debate on an issue of significant public concern. And the details get a little bit more complicated, but in essence, we're arguing that the whole motivation behind these statutes is to stop transparency, and that is a direct affront to the values that animate the free speech clause. These are the decisions. If you want to look them up, I can go into them in a little bit more detail. The first is our Idaho case. In 2015, we got a great decision striking down the entire statute by the district court. That was appealed to the Ninth Circuit, which at the beginning of this year issued its opinion, which was mixed. The great part of it was that the court struck down the prohibition on recording. And so they said there is a guaranteed First Amendment right to document animal abuse and the conditions of factory farms, notwithstanding the fact that these are private property. And that's a major victory. The court said that the prohibition on recording is a content-based restraint on speech, which can't survive strict scrutiny. And so the court struck down that part of the statute. Unfortunately, it upheld another part of the Idaho statute, which prohibited lying on employment applications. And that turned on an interpretation of a Supreme Court case called Alvarez, in which the Supreme Court said, lies are not per se excluded from the First Amendment. There is some protection that applies to intentional lies. The question is whether the lie invades a legally cognizable interest. If it does, then the government has a legitimate interest in prohibiting those lies. But if the lie doesn't infringe on a legally cognizable interest, then the government has no ability to regulate that. And the Ninth Circuit, in I think a overly pedantic reading of Alvarez, said that gaining employment causes a legally cognizable injury to the farmer, and therefore, especially where there's an intent to cause damage to the facility. And so those lies can be criminalized. So in Idaho, part of the statute is in effect the part prohibiting gaining access by false pretenses, but otherwise if you're there, if you got there without lying, if you're a bona fide employee and you see something, you have a protected First Amendment right to document what you see and to share that with the public. The second case there is our Utah win. That case, we won a motion for summary judgment in 2017, and Utah decided not to appeal that decision. So that is final, and that essentially struck down the entirety of the statute. And there, the district court, and this was before the Ninth Circuit, but came to a very different conclusion on the lying by false pretenses portion. So the court, like the Ninth Circuit, struck down a recording ban as a content-based restraint on speech, because recording is a form of speech, and also struck down the prohibition on gaining access by lies, because the court held that there was no trespassory injury to the farmer who hires an employee, gets an employee, but in the process that employee documents misdeeds. And any injury that befalls the farmer by virtue of an investigation that's released is the farmer's own fault because of what the document reveals, rather than the lie told by the investigator. So the Utah statute is struck down essentially in its entirety, and that wasn't appealed, so that's final as well. The third case down there is the North Carolina case, in which PETA was the lead plaintiff. That case, unfortunately, was dismissed for lack of standing at the district court. That was reversed by the Fourth Circuit earlier this year in a decision that said because PETA had a desire to conduct an undercover investigation at a state-owned facility, they had standing to challenge this statute. And this is one of the civil statutes. North Carolina and Arkansas are the two states that have civil ag-gag laws, which prevent some procedural complications that we won't get into. But in light of the Fourth Circuit reversing and remanding to the district court, that case is alive again and currently being litigated in North Carolina. And then the last one there is ALDF versus Reynolds, our lawsuit in Iowa. And that one survived a motion to dismiss. The state sought to have the case dismissed for lack of standing and on the merits. And the trial court essentially sided with the reasoning in the Utah decision. Iowa, I should say, is one of these statutes that just prohibits gaining access by false pretenses. And the court essentially agreed with the reasoning of the Utah decision rather than the Ninth Circuit decision, and said, there's nothing about gaining access to these facilities, doing the job, and recording while you're there that causes a legally cognizable injury to the farm, and therefore we had pled a First Amendment injury. The court, of course, didn't, at the motion to dismiss stage, find that the First Amendment had been violated, but we filed cross motions for summary judgment, and so we're just waiting on the court to decide, but we're optimistic in that case as well. And just to teaser. We do have other cases in the works. So obviously this is a big part of the transparency battle, and so far we're winning. The next category of cases I want to talk about, or the next case I want to talk about, is a Freedom of Information Act case. The Freedom of Information Act is a federal law that creates access to government records to the populace and generally favors government transparency. And of course, as Joyce mentioned, there are not very many federal laws that govern the treatment of animals on farms, and so we don't have a lot to work with. There aren't many records being created in the first place to get access to, but there are a few. This is a picture from an undercover investigation that HSUS did at a battery cage facility owned by Cal Maine in Texas. We wanted to, after that investigation came out, we wanted to get access to the records that FDA had on this facility. There was a egg safety rule promulgated in 2009 by FDA after some Salmonella and E. coli outbreaks that essentially required FDA to do inspections of hen houses and create inspection reports. And we wanted to get our hands on those inspection reports for this facility to see what they said. So we requested these establishment inspection reports under the 2009 egg safety rule in 2011. In 2012, FDA asserted Exemption 4 to the FOIA to heavily redact inspection reports that concealed hen population, cage structure, and bird per cage density. And here's what those documents look like. B4 is the exemption. Exemption 4 allows the government to redact information that it's a trade secret or confidential commercial information, the release of which would cause substantial competitive harm. And so we were seeking information on how tightly packed these cages were and how many birds were at this facility. And FDA, at the behest of the industry, said, we can't tell you that, it's a trade secret. Because if a competitor knew how many hens were crammed into these cages, I guess they would do the same, as if they weren't already. And so, if you look at some of the exemptions, the house caging is arranged in rows with blank birds per cage and blank in the house. There was also even one record that had blanked out how many rats they found in the facility. So yeah, obviously, government is on the industry side here as elsewhere. And so we didn't think that was a legitimate exercise of that exemption. And so we filed a lawsuit in 2012. Federal court granted summary judgment to FDA just because there were competing experts. They had experts that said, oh yeah, this is very sensitive commercial information. We had experts that said it's really not. And the government, the judge sided with the government. The Ninth Circuit, en banc, reversed that decision and remanded it for a trial, which was held just recently, and so we're waiting on the judge. It's very rare to actually have a trial in a FOIA case, but that's what happened, and the judge is currently sifting through the competing testimony of the experts and hopefully will recognize how ridiculous it is to claim that this information is commercially sensitive. And our hope is that this is just another tool we can use to shed light on what's actually happening on factory farms. One last class of litigation. This is false and misleading advertising, which is a large part of our transparency work. And I think, as we talk about how animals are treated, we can expect a sort of faux transparency from the industry. And this is commonly referred to as humane washing, where animal agricultural producers will try to sugarcoat the way they're treating animals and pretend that they're opening up their barn doors and showing you how animals are really treated. And it becomes extremely important to when they try to say, right now it's like this, we're going to say, no, actually, right now it's like this. And so this is a case, ALDF versus Hormel Foods Corporation, filed in June of 2016 in DC Superior Court about Hormel's Natural Choice line. So they have a product called Natural Choice that they portray as natural, clean, of higher standards, and containing no preservatives. And I don't know if you can see this here. The type's pretty small, but here they have this quote from their corporate manager of regulatory affairs, and right above that they talk about where nothing is hiding and no one is left wanting. So obviously they're appealing to the discourse of transparency at the same time we are. And so it becomes very important to use litigation to fight this faux transparency. So in reality, the natural choice products, even though they're portrayed as natural, are produced at the very same factory farms as Hormel's other products, where animals are subjected to gestation and farrowing crates, mutilations without anesthesia, routine use of antibiotics, inadequate veterinary care, and inhumane euthanasia. In our undercover investigation at that Nebraska farm was a Hormel supplier that revealed conditions that I don't think anyone with a straight face could say are natural. The lawsuit was filed under the DC Consumer Protection Procedures Act, which is a DC consumer protection statute. Hormel filed a motion to dismiss, arguing that we lacked standing and arguing that their use of the word natural was puffery. Fortunately, the judge denied that motion to dismiss, and we've been in a total slugfest of discovery for the last few months, really trying to get at the truth. And we have a trial scheduled for mid-2019. So this is a big one to keep an eye on. Similar case, we've sued Trader Joe's over the cartons of their cage-free eggs. This is what their cage-free egg carton looked like, these hens frolicking in a green pasture. Filed this case in March 2018. If this is actually the farm, it's Google Images, a Google satellite view of what the farm looks like, and then a representative photo of what a cage-free egg facility looks like. So not a blade of grass to be seen. We filed our lawsuit alleging violations of the unfair competition law and other laws, and Trader Joe's promptly removed the packaging, and this is what the package looks like now. So, obviously there's much more work to be done than changing the cartons that inhumane eggs are sold in, but if we can take away that hit of dopamine that people get when they buy cage-free eggs and think that they're doing right by animals, then we're pushing forward this idea of transparency. Let me return for a second to the politics of sight to wrap this up. So Patcherat writes that although transparency can be politically transformative, he says where distance and concealment continue to operate as mechanisms of domination, a politics of sight that breaches zones of confinement may indeed be a critically important catalyst for political transformation. Nevertheless, this politics of sight must acknowledge the possibility that sequestration will continue even under conditions of total visibility. And so it's not necessarily enough to focus on transparency. It's not enough to just show conditions as they are, because we live in a society of the spectacle, right, where everything is just an image to be seen, and to actually penetrate and move people to action, we need more than just spectacles of suffering. And so, we have this idea that if slaughterhouses had glass walls, everyone would be vegetarian. And in fact, that's probably not true. And Patcherat writes that this, refers to this as the glass walls fallacy. It relies on an assumption that everyone is going to respond to these images the same way, when in fact we know, probably most of us from our personal experience, even with close family members, that transparency alone, the image alone, is not enough to transform people. So what else can we do? And I want to suggest that we could talk about transparency as more than just shining a light on suffering. And there's a sociologist, Lauren Corman, who's written about the animal rights movement's perhaps over-focus on animals as vulnerable, suffering victims, that we might talk instead about animals having rich lives. And Susie's stories about Rose and Nikki, I think, is a beautiful way of doing that. Lauren writes, Professor Corman writes, we must take seriously animals' exploitation while refusing to reduce non-human animal subjectivities to representations of suffering and victimization. We must discuss suffering, but we should do so in conjunction with other, richer versions of other animals' experiences beyond suffering. And so it's not just about revealing the horrors that animals endure as anonymous subjects. It's about actually letting their identities shine through. So part of the etymology of transparency is this idea of shining through. So I think in addition to just shining a light on the dark places where animals are suffering, we have to create representations and make space for representations in which the internal light of animals is allowed to shine through. And I think that's exactly what Susie is doing in the sanctuary movement, Patrice Jones in the sanctuary movement, Joanne MacArthur's photography, I think is getting at this idea of letting animals shine through themselves. And that kind of transparency, I think, has the real potential to not only expose suffering, but also to be truly transformative. Thank you.
Good morning. So as Tom said earlier, my current role is as captive animal law enforcement with the PETA Foundation. But the work that I'm going to talk about today and the initiatives I'm going to talk about today were done when I was the Deputy Director of Advocacy with the MSPCA. And so it's going to be, my comments are going to be from that perspective. So in November of 2016, close to 78% of Massachusetts voters, which was more than 2.5 million people, went to the polls and voted to give mother pigs, egg-laying hens, and calves raised for veal some basic freedoms of movement: to stand up, to lie down, to freely turn around, and to fully stretch their limbs. And this applied whether the animals were born and raised inside of Massachusetts or elsewhere. And this was a strong and decisive victory for farm animals. It was the largest margin of victory of any ballot question in the century-long ballot question history in the Commonwealth of Massachusetts. And voters were able to do this because Massachusetts is one of 26 states that offers the ballot question and direct democracy as an option for its citizens. And so today, and we started hitting on this morning in the earlier talk, I'm going to talk about how the ballot question can serve as an effective alternative when statewide legislation isn't doing the job for farm animals. And I've spent a lot of time working in legislation, and I believe that's an incredibly effective mechanism for making change for animals. And you inevitably run into roadblocks, and oftentimes you can strategize around roadblocks, you can compromise around roadblocks, but especially as it relates to animals that are raised for food, you tend to run into roadblocks that just persist legislative session after legislative session, and you can't strategize around them, and you have to compromise so much that you're not doing anything anyway. And so, if you kind of have to take a step back and you have to say, are we going to continue banging our head against this wall, or are we going to take a different tact? And so, the ballot questions can be a really powerful tool to push that change at the state level where our state legislatures aren't acting. And they can be also, as you go through the process, really great tools for increasing industry accountability and transparency. And so I'm going to talk about a few things today. I'm going to go through some background about ballot questions and what they require for those of you that haven't worked on one or aren't from a state that has the ballot question process. I'm going to talk about the road to the ballot and how the process itself helps to increase industrial agriculture transparency. I'm also going to talk about the substantive legal changes that are made from these ballot questions and how they can push beyond the bounds of state law. And of course, nothing good comes without a price. And so I'm going to talk about some of the challenges that come with these particular initiatives. So first, a little bit of background about ballot questions themselves. As I mentioned, more than half of U.S. states have the statewide initiative petition as an option, and this includes agricultural states. Ballot questions broadly were designed. They are by their very nature tools to go around the legislature. They were written into state constitutions and passed into state law so that citizens could take action when the legislature was not acting in the will of the voters. But because of this, they are purposely structured, either in constitution or statute, to be really hard. They take significant and concentrated effort to get to the finish line and over the finish line. And the idea is that if you're going to go around the state legislature, the people who have been elected to make policy change in your state, you're going to have to show that a not insignificant number of voters actually want to see this change. So this is from Massachusetts, and this is just an overview that our Secretary of the Commonwealth provides of the major steps, not even all of them, to getting an issue on the ballot. And what states do is they set up a series of really strict and firm deadlines and benchmarks that campaigns have to meet in order to get on the ballot. And these are different in each of the 26 states, so I'm not going to cover all of them today. But there are some commonalities amongst the majority of states. And the very first step in most states is for groups that are interested, in a ballot question to form a ballot question committee. And what the ballot question committee is a separate political entity that is tasked with accepting donations on behalf of the issue, on behalf of the campaign, making expenditures on behalf of the campaign, and very accurately and specifically tracking those expenditures and donations, and according to state law, generally reporting those to the public. If there's going to be staff hired by the campaign, if there's going to be staff hired, the campaign will do that. And states have other strict reporting deadlines that go on during the campaign and even beyond the pendency of the campaign. We just filed our last, I think, ballot question reporting campaign to the state of Massachusetts, and the campaign was over 2 years ago. So once you've formed this ballot question committee, this political legal entity, the next step is to actually file language. And so file the language with the state that you want to see put before the voters. And I'll talk more about what the language of question 3 was later. And then once you've filed the language, these are the 2 easy steps, then you move on to the signature gathering phase of the campaign. And so this is an actual copy of the initiative petition that Massachusetts residents will sign and that they signed for question 3. And I put this up here because other than actually winning at the polls, this signature gathering phase is the biggest benchmark of the ballot question campaign. It is a ton of work. It is a ton of time. And if you can't do it right, you're not getting your issue before the voters. And most states have 1 round of signature gathering. Massachusetts is a minority in that we actually have 2. But the goal of this phase, and what you're required to do, is to collect a number of certified signatures in a usually fairly tight timeline. And the number of signatures is predetermined. It's usually based on the number of voters in the most recent election. In Massachusetts, it's 3% of voters who voted in the last gubernatorial election. And to give you some sense of numbers and what this really means on the ground, in Massachusetts, we had to collect a minimum total of around 77,000 signatures. 67,000 of those had to be gathered in an 8-week time frame. In California, where they're currently considering Proposition 12, which would pass provisions that are similar to the Massachusetts law, they had 180 days to collect a minimum of 365,000 certified signatures. So these are big undertakings. And it's important to note that these are certified signatures. So, I couldn't just pass one around this room and have you all sign it, which would be really great. They actually have to be registered voters in the state in which you're trying to move this initiative forward. And because there's a really high bar, there's actually a legal bar for what these signatures, the standard for these signatures. And so basically what happens is each campaign has to take every single signature that they get and they have to send it off to a designated governmental entity. In Massachusetts, it's each of our 351 cities and towns. And our town clerks will look at the signature, they'll make sure that it's a real person, that the signature has to be legible, they have to stay within the boxes. If it's not in the boxes, the signature doesn't count. They have to be at the address that they provided, they have to currently be registered to vote there. And if the town clerk can't confirm any one piece of that information, he or she literally takes their red pen and just scratches right through that signature, and it doesn't count towards the final tally. And campaigns, depending on how their staff and volunteers are trained, depending on the jurisdiction where they're submitting the signatures, can have anywhere from a pretty low 15 or 20% attrition rate, but some campaigns have seen 50% attrition rate. So they're losing half of the signatures that they're gathering. And so because of that, smart campaigns plan to collect tens of thousands more signatures than they actually need to get on the ballot. This is an amazing campaign volunteer, Tessie, who is charged with managing some of that paper that is generated from all of these signatures. But in addition to the rules surrounding the signatures themselves, states have other rules that make it difficult for the signature gathering phase. Most states have geographic restrictions so that issues don't get on the ballot just upon the will of voters that are in major urban population centers. In Massachusetts, even if that town clerk signs off on those signatures and our Secretary of Commonwealth does his final review, and there is a scratch on the page, there's a stray mark on the page, there is a tear on the page, he can pull that entire page of signatures out and discount it from the final total. More and more states are putting stronger requirements on signature gatherers themselves. Some states are requiring signature gatherers to certify that they're residents of the state or meet certain restrictions, and they have a strict review of what these signature gatherers are doing, such that if they find that the signature gatherer didn't certify something, they will throw out every signature that signature gatherer got. And so this is really the phase of the campaign where most campaigns fail. And to demonstrate this, in Massachusetts, only about 20% of campaigns that form a ballot question campaign, that file the language, actually eventually end up making it to the ballot. So it's really a lot of work. But if you're successful, then eventually you will get a ballot question number, and you can move on to the persuasive phase of your campaign. And so I've already said this, but in Massachusetts, we were the question 3, and we were the Yes on 3 campaign. And I want to pause really quickly to say, because I know that coalition building came up this morning, and yes, ballot questions are an incredible way to engage in coalition building. Of course, as Joyce said, the Humane Society of the United States really led this effort. They put in the bulk of the money that went into this campaign, but the ASPCA was involved, the Center for Food Safety was involved, ALDF was involved, our local zoo, Zoo New England, was involved, the Massachusetts Sierra Club was supportive. And so these really are initiatives where you can pull in a lot of groups and a lot of people to help move it forward. And you need to do that, because to be successful in this first phase of the campaign, as well as the persuasive phase, you really have to have a solid infrastructure. You have to have a strategy. You have to be prepared. You have to have money and the ability to pay staff or pay signature gatherers. And if you don't have that money, in the absence of that, you have to have virtually a real army of volunteers. And we're pretty lucky in the animal world because we have pretty amazing volunteers. And while the ballot question process does raise significant hurdles, it's also a real opportunity for people like these amazing women and all of us in this room who care about animals to engage with citizens and to talk to them about an issue that we want to see supported on the ballot. And here it's how animals are raised for food in our country. And these engagements happen in a number of ways throughout the campaign. I've already talked about the mechanics of signature gathering, but the really, besides from getting on the ballot, to me the most important part of it is that it's the talking that you have to do to get those signatures. In Massachusetts, the Question 3 campaign, we ultimately got 170,000 certified signatures. In the California campaign, their final tally was over 600,000 certified signatures. And so when you think about those attrition rates that I was talking about earlier and looking at these campaigns in their totality, together those campaigns generated at least over 1 million opportunities for conversation about industrial animal agriculture. And what's key are these are actually meaningful conversations. I've been on the ground in a number of ballot question campaigns, and I can tell you, people will not sign them unless you tell them what the issue is, why you support it, and why they should support it too. And so these conversations start to happen around this issue. But it's not only the signature gathering phase. Once you get on the ballot, you actually have to wage a full-scale political campaign. You have to go to the doors, you have to get to the phones, and you got to get to the airwaves. And in Massachusetts, on average, in the weeks prior to the campaign, volunteers were knocking on close to 8,000 voter doors per week. Volunteers from across the country were calling thousands of registered Massachusetts voters to talk about this. I just got an email on Thursday, I think, from the Prop 12 campaign, and they said in 48 hours, they had made 20,000 voter contacts, and their goal was to make 1 million before the vote in November. I mean, that is an incredible amount of outreach on this issue. And of course, the work isn't only done via one-to-one outreach. We also go to the airwaves. Could you play the video?
Pigs unable to turn around, hens crammed into tiny cages. Responsible farmers would never allow this extreme confinement. All animals deserve humane treatment, including farm animals. Yet right now, there is no law in Massachusetts to prevent cruel confinement. We can do better. So join us and vote yes on question 3 for healthier animals, safer food for your family, and to prevent the cruelty.
Yes on 3, to protect all 3, animals, family farmers, and us.
And I think about every time I see that ad, what I think about are kids who may have just been watching TV with their parents, and for the first time in their entire lives, they have this small snippet and they can see for a moment what animal agriculture actually looks like. And perhaps it moved them to have a conversation with their parents or to have a conversation with their teachers about where their food comes from and why are we eating animals. And I find that to be very hopeful. And in my view, it's these engagements that are part of the ballot question. It's why it's such an incredible tool for increasing transparency in animal agriculture. And it's not, because the process doesn't only allow, but it essentially requires that these conversations and that these engagements happen with vast numbers of people on the issue. And I think, to Matthew's point, something that was really, I thought that the campaign did very well was, and you could see it in the ad, they balanced these harsher images of animal agriculture and how we see animals in farms with, animals that are living freely and just being animals. And the campaign did that throughout all of the materials and collateral that was part of the effort. But what's important, moving on to the next slide, is that these campaign-driven conversations aren't the only ones going on around the issue. The media picks up on these issues. The majority of the states that have ballot questions only have a handful of them on every year or every election year. Most of them, it's around an average of 4. There are outliers like Colorado and California that tend to have a dozen or more, but for the most part, it's around 4 issues. And so what that means is these become major political issues in the state, and the media picks up on them and they are hyper-focused on them. In Massachusetts, every major paper's editorial board will come down on a position of every single ballot question. But it's not just the editorial boards, columnists pick up on it, reporters pick up on it. And so these can be really great opportunities, again, as Matthew was saying, when you get media coverage on this issue, you start to make change and you start to take this conversation to a whole other level. Radio stations cover these in Massachusetts. Our state's highest officials are basically hounded until they come out with a position on each of the ballot questions. Again, that's driving more media coverage. It's not just statewide coverage, it's local coverage. Local newspapers will pick up on advocates that are working in their communities. The letters to the editorial pages on local papers, there's literally conversations happening on those editorial pages. People are writing letters to the editor, back and forth, talking to each other about these issues. And so it's bringing animal welfare and animal agriculture into our neighborhoods and into our communities. And I think that's pretty incredible. And what's important is this conversation goes on for months before the campaigns are certified and all the way through and past the election day. And so while these ballot questions are an unbelievable amount of work, the process itself amplifies the conversation about animals that are unseen and that are suffering in our industrial agricultural system in a way that other advocacy efforts don't always have the opportunity to do. But it's not just about the process, and I do want to talk a bit about what the substance of the law is. And before I do that, I talked about how ballot questions can be a tool when you can't get your legislature to move, and that's basically what happened in Massachusetts. The first bill filed on farm animal confinement was in 1987, and following that, there were budget amendments, there were sessions where there were multiple bills filed, there were sessions where there was only one bill filed, there were sessions where there were bills that tried different tacks, but ultimately, nothing was successful. Our legislature was not going to move on this issue. And so advocacy groups that work in Massachusetts made a decision to take it to the ballot. And so what was ultimately filed was an act to prevent cruelty to farm animals. And it covers some very familiar animals. Any pigs during her pregnancy, calves raised for veal, and egg-laying hens kept on farms. And the law defines egg-laying hens not only as domesticated chickens, but turkeys, ducks, geese, guinea fowl. I think I'm missing one. No, that's it. And so that's who is covered by the law. The law creates 2 major prohibitions. The first, again, is probably very familiar, confining any covered animal in a cruel manner, and that is defined as preventing that animal from lying down, standing up, fully extending its limbs or turning around freely. And fully extending the animal's limbs is defined in law as extending all of his or her limbs without touching the sides of the enclosure. And chickens are required to have an additional access to 1.5 square feet of usable floor space per hen. So just getting this prohibition passed into law was a victory in Massachusetts. This is what we couldn't get done in our legislature. But a lot of the real power of question 3 came in the second prohibition. And that prohibits from selling within the state, from businesses from selling within the state, shell eggs, whole cuts of veal meat, and whole cuts of meat from pigs that are from covered animals that were confined in a cruel manner. And in the case of pigs, it not only includes the mother pig, but also her immediate offspring. And so obviously this substantively went much further than anything the Massachusetts legislature would have passed. And that's one really fantastic thing about ballot questions, is that you can stretch, you can be bolder, you can take more risk than you can with a legislative process. Because, with a legislative process, compromise is inherent to that process. It's essentially built in, and it's not built into the ballot question process. And you're certainly going to have to make your case to the voters. But initiative petitions give you that chance to go farther because you don't have to compromise. And we saw that play out in Massachusetts. It was an opportunity to push further. Advocates took it. And now, once the Massachusetts law becomes effective, it will be the broadest and most comprehensive law on confinement for farm animals that has been passed in the US by a state legislature, by ballot question, or by regulation. And so, getting back to the theme of our talk today, it's by going farther, that we're able to create some industry accountability with these state laws. With both of these prohibitions codified into law, the goal is to continue to push producers both inside and outside of Massachusetts and to hold them accountable for certain ways in which they treat animals. Businesses that have made commitments about confinement practices are going to have to follow through with them if they want to participate in the Massachusetts marketplace. This law holds them accountable for those processes. And it also holds local businesses accountable. They need to know where their food is being sourced, or they cannot sell it in Massachusetts and be in compliance with the law. And our Attorney General is going to hold them accountable. And so, broadly speaking, accountability really was a key part of the substance of question 3. So those were the good things, and I do want to take time to talk about the challenges of the law. I talked a bit about infrastructure. I'm not going to cover that again. Media messaging. The media coverage can be great, but the first rule of media training is that you don't control the media, and so you have to be prepared as a campaign. It's, again, having that infrastructure and being willing and able to engage with the media and having media-savvy people on your team and having a really strong messaging digest and messaging documents so you're always staying on message. Cost is a huge factor with these ballot questions. There have been some studies out of UMass Boston on the Massachusetts ballot questions that show that the lower spender usually doesn't win a change in the law. So you have to be ready to spend money. And to Joyce's point earlier this morning, it is, often the national groups, it is the national groups that are pouring in the vast majority of the money into these campaigns. In Massachusetts, the campaign spent $3.6 million to get question 3 successfully over the finish line. I checked last week, the proponents of Prop 12 in California have spent almost $9.5 million on that campaign. These are not small amounts of money. And opposition money is another huge wild card. We've seen so many times in Massachusetts when there are issues that have broad citizen support, they get lots of signatures, they have a great campaign, they have a great infrastructure, they're getting great media coverage, but then outside money comes pouring in, corporate money comes pouring in, and the issue completely tanks at the ballot. So it's a huge wild card that you just can't factor for at the beginning of the campaign. Legislative pushback is a huge issue. There is obviously a real tension between legislatures and the initiative petition process. And legislatures are, in 19 of the 26 states that have ballot questions, legislatures can overturn or amend the law after it's passed by voters. California is the only state where the legislatures can't do anything to a ballot question. There was a recent Pew article that talked about how 2016 saw the greatest number of statewide ballot questions in 10 years. And legislatures are being responsive to that. They're passing laws that make it harder and harder for citizens to get issues on the ballot in their state. Legal challenges are a huge issue. Post-certification challenges happen. A 2006 ballot question that would have prohibited greyhound racing was kicked off of the ballot on a state constitutional challenge. And opponents of question 3 did try to do the same thing, thankfully unsuccessfully. After the law has actually passed, of course, you're open to litigation. And for folks who have followed California, that's been happening there for well over 10 years after Prop 2 and the following legislation passed. And after Question 3 passed, Massachusetts was sued by 13 states who also sued California. So that outcome is still yet to be determined. And but these are real and big challenges to the ballot question process. And so that's why groups like the MSPCA and like the Humane Society of the United States don't take these issues on generally unless they have tried legislation first, because they're really risky and they're really expensive and they may not go your way. And so you have to be thoughtful about whether that's what you want happening for farm animals. When we're going out there, we want to be successful. And so as I close, I did want to take a moment to acknowledge an important view that questions whether these ballot questions go far enough. Specifically their recent use as it relates to animals that are raised for food. And there's an idea that if you're going to spend this much money, if you're going to activate the animal base and ask them to do so much work, if you're going to spend this much political capital, then you need to be doing more than just trying to change these confinement practices. There were some organizations and some individuals in Massachusetts who didn't participate in the ballot question because of that. And in fact, my current organization, PETA, has taken a position in opposition to Prop 12 in California for similar reasons. Now, PETA has specific concerns about the specific provisions related to egg-laying hens, but they've also expressed concerns that when we do this, we're just, again, codifying these practices into law and keeping animals in these conditions for longer. And PETA's also argued that Californians would support more than what the ballot question is proposing. I don't think there's a great answer to this question, but when I think about the two sides of this coin and I think about my personal experiences on these ballot questions, I agree. Obviously, I said that today. I do think these ballot questions give us an opportunity to go further, and especially in a state like California, where we've seen that voters there are supportive of this type of initiative. But I think the thing about ballot questions is, while I showed you the great media and we had a 70% approval rate from the voters in Massachusetts, you don't feel that until you get to 8 p.m. or 11 p.m. when the results come out on election night. While you're in the middle of it, it feels like a head-to-head race every single day, and for every single signature and for every single bit of media that you are going to get. And so I think that dynamic, combined with the wild cards of media coverage, of opposition spending, you can't know what the outcome's going to be. And so that tends to push you to say, well, maybe we could go further, but we're just going to push this much further because we still have to make our case to the voters. And I think that the end result is imperfect. I don't think anyone in any of these organizations want to see animals confined for food, cage-free or not. But I do know on the ground, and as I've talked about today, the conversations that happen around these ballot questions matter. Voters in Massachusetts took this issue really seriously in 2016. Quite literally, millions of people who hadn't before considered where their food comes from, they had to pause before they circled in the yes, or they colored in the yes button on their voting form. They had to pause and say, yes, I see these animals and I want them to have at least some improved conditions. And for that, just for that moment, they saw those animals. And the hope is that they will continue to see them as we continue all of these different advocacy efforts into the future. And I think that's the real start in just getting people to see and to think about where their food comes from. And I think that's one upon which we can all build. So thank you.
Okay, so I'm going to come down and be with you, all right? You're my jury. How about that? I'm Michelle Welch, and I'm the director of the Animal Law Unit, and I am talking about holding people accountable through the criminal process. So last year, we did about 58 special prosecutions, and I'm going to talk to you about one of them. This case was brought because of an undercover operation by Compassion Over Killing. Anybody here from Compassion Over Killing? All right. They're very good. And I will say, I had never dealt with them, and I wasn't really sure about them because I had not had any previous dealings with them. But the first thing they did was they sent a letter to 3 Commonwealth attorneys. In Virginia, we're a Commonwealth, so it's what you would call a DA. So they sent out a letter to these 3 Commonwealth attorneys, and then they released the video to the public. Now, just so you know, I'm never going to talk about my case until it's done, right? When I'm done with that jury, there's ethical obligations, right? You don't talk about your case. And so at first I was like, what are they doing, right? But it was a really good strategy because what happened was the Commonwealth attorneys took it much more seriously. Let me get back for a second. So what they did was they charged their animal control officers to start corroborating it. You know, the undercover videos are great, but as a Commonwealth attorney, I have to corroborate it. So those Commonwealth attorneys, it was Lunenburg, Mecklenburg, and Buckingham. It's rural Virginia, all right, kind of middle Virginia, if you don't know Virginia. And this is one of the first prosecutions in Virginia at a Tyson breeder farm. It is the first, and Compassion Over Killing told me it's the first in the nation as well, where we actually had a prosecution. So how do you win these cases? Well, there's no crying aloud. So I'll tell you, I've been an animal abuse prosecutor for about 20 years. Next year will be 20 years. And I have been treated lightly in court, and that's when they make their first mistake, because I've done everything from graffiti cases to homicide cases to sexual abuse cases. So when I do a case, I come at it with all my guns, right? I'm going to be more prepared than anyone else. I'm going to have thought about every defense they might make, and I will have prepped everyone thoroughly. So being prepared is the second way you win. And I'll tell you, in busy Commonwealth attorneys' offices, that is the mistake they make. They make it on other cases too, right? If you're not prepared and you think you're a legend in your own mind, and you think that you can go in there and talk to that vet, and he's going to know what you're going to ask him, and he's going to be good on the stand, that is a mistake. So being prepared is really, really important. And treating it like any other criminal case, making sure you do it seriously. And then demanding that everyone else treat it that way. So the way I first got involved with this case is the animal control officer, Ray Elliott from Lunenburg, called me up and he goes, Michelle, how in the world do I corroborate it? So we talked that over. And he called up Tyson. And he got the employees' names. And they were very cooperative. I'll tell you that Tyson fired them all right away once they saw the video. So that was, you know, they were much more helpful. So you have to corroborate it. So we had to make sure that we knew who they were, right, and what they were doing. So this is the Lunenburg Commonwealth attorney. It's probably the best letter anyone's ever written about me. And he just said that I have been the Commonwealth's attorney for 36 years. He's very respected in the state of Virginia. And I have rarely seen a more prepared, organized prosecution. Michelle stood her ground against some tenacious senior members of the bar in a very professional manner. She did not hesitate to try the case, and her presentation of the facts and the law obviously led the judge to come to the conclusion. So the first couple of cases we had, so the way these cases work, even my wildlife trafficking case that I just did, we have to try a couple. And then they realize that we're serious and that we're going to get the outcome that we want, which is a conviction, all right? And so that's what we did here. And I will tell you, the defense bar thought I was crazy, and they said some pretty derogatory things to me, and I just smiled. And as many times as they told me to call them by their first names, the nastier they got, the more I called them by their last names, all right? And we got very professional very quickly. And I remember one in particular said, well, where are you getting your vet? New York City? And I was like, no, Buckingham. And he has a fabulous name, and I basically had to look around, and I tried to get some national experts, but they're all on some committees for the big producers, and so obviously they're conflicted out. So I went to my sources in Virginia, and I know a lot of agrarian vets, and so I called them and I said, who do you think would testify for me? And they gave me his name. And I'm not going to tell you his name because I don't want it to get all the way out there, but it's a very fabulous Southern name, all right? So, but when I called him, I said, now, I'm a little worried because there might be some pushback. And he said, I don't care, because I had already showed him the video. And, you know, the defense was going to be standard animal husbandry practice, right? And so we have to overcome that. And so I showed him the video, and he said, that's not a standard animal husbandry practice. And he knows because he does chicken cases all the time. Like, he inspects these, you know, not inspects, but goes in and does vet treatment. You also have to be unapologetic. And I'll tell you that the first jurisdiction, it's a judge that I have a lot of respect for. And I was nervous because I was really worried he was going to let me down, right? And that, you know, because it's a chicken, he wasn't going to take it seriously. And I've tried sex cases in front of him. I've tried dogfighting cases in front of him. And so I was really more nervous about him because I was like, oh, if I prove it, and I'm going to prove it, you know, I want him, you know, to do the conviction. So you got to bring your A game. So I've only included, there's only one video that well, you may think it's worse than me, but I tried not to be gratuitous, but I'm going to show you something. So the way our cruelty law works is we have intentional cruelty in the first clause, and then we have like deprivation. We used ill treats, and if you know what ill treats means, it's the dictionary definition of that. It's maltreat, or badly treat, or cruelly treat. And so this video, oh, wait a minute. Can you play the video? It's not playing for me. Thank you. So in this video, you will see one of the people, and he's swinging the chickens. They're crowding them from one side to basically bring them all the way to the other side. And he's swinging them to basically herd them. So I didn't have anything that really fit that under my statute, and so we used ill treats. And the doctor, the vet, got on the stand and said, that's not how you're supposed to do it. And he explained that to the judge. And so we used ill treats. I will tell you that that's going to serve me well later when I have other cases I want to use ill treats for. So they sent the video to the 3 jurisdictions. The 3 jurisdictions called me and said, will you do it? And I was like, yes, I will do it. And I did. And so what we did was we had to look at hours and hours of video. And the prosecutor, the CA in that jurisdiction, when I sent him, we basically brought it all the way down to the worst of the worst, because it's the first case. I'm not bringing anything borderline, and it was the worst of the worst. And when I sent him the videos, and I said, this is what I'm going to do. These are the indictments I want. Here's the language. Indict them for me. And he's like that. He said, you know, I have to commend you. It's like a child pornography case. He said, you had to do, because remember, he had the raw footage to begin with, so he knew how much video we were talking about. He said, you know, I have to admit, I have to really applaud you and Kelsey Block, who is one of my lawyers, who's fabulous. And because we really distilled it down to the worst of the worst. And we went through it meticulously. So in the videos, they were kicking and throwing chickens. They were crushing chickens to death, which I'll show you. And they were boning chickens. They were crowding them to load them, and they were cruelly killing them. So our statute says you can't cruelly or unnecessarily kill an animal, all right? And so that's what our theory was, that he was not unnecessarily killing, but cruelly killing. All right. Can we go back? There we go. So the first time you see him doing this, he's doing it the right way. And we've included that in the video to show that he knew how to do it the right way. And then you'll see him pick up one of the chickens and just huck it. That's a southern term, hucking it. And throwing it into the transport cage. So there we go. There we go. So they did that repeatedly. And some of them were worse at it than others, but every time we saw them do it, and we had to watch these videos over and over again, and at some point, Kelsey and I got really desensitized. And I was like, God, it doesn't look that bad now to me. And so we basically brought in one of our paralegals who raises chickens, and I was like, okay, watch this, and tell me, like, is that bad? And she's like, oh yeah, that's bad, get him. And so we did, of course. So that's what, it even happened to us. And what we realized was they were kind of infecting each other, you know? Like the more desensitized someone was and the more bad behavior, the other people would get like worse, you know? And so they were infecting each other. I'm really proud of, can you play this video? I'm really proud because we took a chance on the boning. Because I looked at it, and I know it's a standard animal husbandry practice, but I think it's cruel. And so we indicted on boning. And you'll see him, he basically, if you don't know what it is, I know most of you are very savvy, he takes a plastic strip and he shoves it into the chicken's, I guess that's the nose or the beak. And so you see him doing that. So because of our case, Tyson has prohibited that. The reason they were doing it was that the male chickens would eat all the female chickens' food. And so they had, it's an old farm, and they're not as automated as some others. And so they were doing that so that the male chickens wouldn't eat the female chickens' food. So we did it because I felt like, you know, I'm standing the ground. I think that's cruel. And it's my choice, right, because I'm indicting. So then we have, and this is kind of the most, can you play this one, please? This is the most gratuitous. This is the crushing of the chickens to death. So no matter how, they get paid the same, whether they work the whole 8 hours or whether they work 4. And so one of the defendants would basically bring the forklift in with the transport cage, and he would just ram it up in there. Nobody would get the chickens out of the way, and he would put it down on top of the chickens. And you'll see a chicken still alive right there. And so we charged for that as well. So it was a pretty simple case, as my cases go. Dogfighting cases can take a long time, and there's a lot of witnesses. But for this one, it was pretty simple. I had the ACO on first, and they basically corroborated the information. He's the one that points to the defendant. That's the defendant in the red shirt beside counsel table, right? So identify the defendant. He also identified it was in Lunenburg, or Mecklenburg or Buckingham, respectively. And then I put the undercover one, and I'll tell you, the undercover had never testified, ever. Was a young man who I grew to really, really like. He's a really good kid. But as you pointed out, you can't lie about your employment, and he didn't. But one of the defense attorneys threatened me and said, oh, well, is he really a vet? Because he said he had been in the military. And I was like, yes, he's been in the military. But when he came to court, I'd never met him before, right? And he kind of had scraggly hair. And, you know, I try not to judge anyone because I don't want anybody judging me. But he had scraggly hair, and it didn't occur to me that it was a wig. And when he was on the stand on the first day of the first case, the defense attorney, of course, trying to make hay, said, are you wearing a disguise? And he goes, yes, I have a wig on. And I was like, why are you wearing a wig? But anyway, the other thing that we kept banding about, they did not want to put the undercover on. And as someone who has dealt with a lot of undercovers, I had a big cockfighting case where I had to burn my undercovers because you got to put them on. You have a right to confront your accusers, right? So I said, well, you got to go on the stand. I was like, and believe me, more than anyone else, they're coming for you. So you really, so we prepped like 3 times. He was nervous. But at the end of the day, he was awesome because he came across as very credible. And that's what you want as a prosecutor, right? You want a credible witness. And so he was very good. And in the end, they didn't make much headway with him. And then I put my veterinarian on. And he was amazing. And there was a couple times he had never really testified in court either. And I told him, I was like, no matter, they're going to bait you, no matter how much they get nasty, you've got to stay like steadfast, right? Very professional. And he did, but there was one time when he kind of gave it back to him, and I was okay because it worked for me in that particular instance. So like I said, Kelsey and I went through lots and lots of video and we got there. So standard animal husbandry practice. He was so good on the stand because he said, crushing an animal to death is not a standard animal husbandry practice. He said, the bottom line is they get paid for every chicken, the farmer does. And so you would want not to do the kinds of things that they did. So the man I showed you, he actually owned the farm. And his trial was the longest. It took about 4 hours. And it was a bench trial. And it was a judge that I had not been before, which happens a lot with me because I'm going all over Virginia. And I was a little worried about him. And so what we did was we just laid out the facts, right? And I told him what the law was because I know the law, right? And I said, this is ill treats. And I got the vet to talk about ill treatment, cruelly killing, crushing them to death, throwing them the way they did. Like none of that is a standard animal husbandry practice, no matter what they wanted to do about that. I had one defense attorney who was really emotional about this case. And as a woman, the women in the room, we can never be emotional, right? And if we are emotional, we get labeled a woman, right? But he was really emotional. And he sent me this email that was so emotional. And I took a minute, and I then responded to him. And he was just really incensed by my first plea offer. How many prosecutors do I have in the room? Okay. So the first plea offer, that's like, that's your wish list, right? So you're trying to get as much as you can. And so he was outraged by me. And so, he had lovely language about how unreasonable I am and blah, blah. And so I said, and I won't say his name, but I said, Mr. Smith, that's not his name. And I said, Mr. Smith, this is a negotiation. If you have a counteroffer, please make it. Otherwise, I'll see you in court. And so I wasn't even that flipped. Best regards, Michelle Welch, right? And so then he was with another lawyer who I'd worked with a lot. We had done sexually violent predator cases against each other, and he's a really decent guy and really very appropriate, right? And so he started getting him to call me because he was thinking, oh, well, maybe he can get something else out of her. So in the case, I'll tell you, you can tell I love to be on stage, right? And there's nothing better than a trial. Right, Diane? Diane's back there. So I was on fire. And sometimes you're like, oh my God, I am rocking it, right? And I'm not rocking it every day, but sometimes I'm rocking it. And so every single objection, because he was doing all kinds of good old boy stuff on me. And good old boy, that's a Southern thing for someone who's old. Okay, and trying to get over without the law. So anyway, and so I kept objecting, and the judge, remember I was worried about him, he kept sustaining the objections. And so I was like, oh my God, I am on fire. I am winning the battle, but am I gonna win the war, right? Am I gonna really get this conviction? He put on an expert who was a chicken farmer. So for those law students, if you know, an expert's someone who has more information than the judge, right? So I didn't even object to the chicken farmer, but you betcha I crossed him a lot. And so what I said to him was, I was like, well, how much you being paid here today, right? Because that's bias. And so he told me that, and I was like, well, how long ago were you a chicken farmer? He goes, oh, 10 years ago. I was like, would you agree with me that from 10 years ago to now, some things have changed in chicken farming? And he's like, oh, yeah. And I was like, okay. How much did you make as a chicken farmer? Now, that's the question he didn't want to answer because his whole community was there. And he didn't want them to know that he was making $100,000 as a chicken farmer. Now, I got to tell you, I'm a government lawyer. I don't make $100,000, okay? So I was like, $100,000? Okay, so I didn't even expect that. But then I said, because when you take the stand, I'm going to go for you, right? I was like, well, when you were a chicken farmer, did you crush chickens to death? And do I care what the answer to that question is? Oh, no. So I go to the next one. And I go, when you were a chicken farmer, did you throw chickens into the transport cage? No. And I was like, so when you were a chicken farmer, did you just routinely abuse animals? No. Enough questions, done, right? So at the end of the day, the judge found for me. And both judges, the one that I was worried about that I really have a lot of respect for, they both said before they entered judgment, they said, well, I sure got an education today, Miss Welch. And I was like, yes, Judge, yes. So we had 9 defendants, 3 jurisdictions, I got all convictions. We had 2 bench trials. And the last thing I'll kind of leave you with is, what is justice? So remember, it's hard for me to get justice on a dog fighter. It's hard for me to get justice on a companion animal, and they're cute and cuddly, right? And so we felt, and I will tell you, I take it very seriously when I'm working with a national organization or even a local SPCA, that I want to hear what you have to say. But at the end of the day, I'm the boss, right? So I was like, you know, I really doubt we'll get any jail time. And so it was helpful to try the first 2 because then I knew what the judges were going to do. They basically would not give any jail time, but what we wanted was a prohibition on working with animals for a period of time. So of those 9 defendants, I got 1 year on one, I got 3 years on one, I got 5 years on one, and on a plea agreement, I got 10 years on one, all right? So they're not going to be working with animals for a while. Plea agreements, you know, can be a dirty word to animal advocates, but sometimes knowing what I can get in a plea agreement is exactly what justice looks like for me. One of the defendants, he was stepping, and this is why when the defense attorneys were giving me a hard time, especially the one that was so emotional, I was like, your client stepped on a chicken's head, looked at the undercover and said, don't do this. This will get you 10 days in jail. And the inhumane, not the Humane Society, he called it the Inhumane Society will come after you. So anyway, so I was like, so don't be so righteous. And your client did the crime. I have it on video. We're going to prosecute him. So just don't always expect jail time because we have to meet the judges where they are. This is my unit. Kelsey is right there. She is smarter, faster. She is the bionic woman. And at the end of this month, she'll be arguing for the Virginia Supreme Court. And my heart is full. In the 3.5 years that we've been the Animal Law Unit, we actually have done 820 matters. We have 22 special prosecutions this month. I have 3 dogfighting cases that will be going to jury. This is my information. I'm happy to talk to any of you afterwards. For the law students, I know I keep saying this, but criminal law is really fun. Okay, so think about it. Thank you.
Okay, we have some time for questions for Michelle, Laura, and Matthew. If anyone would like to come up, the microphones are on either side.
Thank you all for your presentations. I had a question about the Proposition 2. Why was it a stipulation in the law that it was whole veal and whole cuts of meat and not other, whatever you do after you cut them?
Yeah, that's a great question. I think that, so the law actually specifically says that it doesn't cover combination products. It does cover it if there's like a whole cut of meat from a pig that has seasoning or that type of a thing. And I think it's just for the clarity of the law, especially because this was the first time that they were going after this. And they actually didn't even do, in the Massachusetts law, they just did shelled eggs, so not even liquid eggs. The California law does now include liquid eggs, so it's kind of the first time they're pushing beyond that. But I think as they were going for this the first time, it was just kind of just, it's very clear what that is. Because then once you start to get into things like prepared soups and, you know, what's in the, you know, Campbell's chicken noodle soup, what's in the hot dog, you know, it gets much, much muddier. And so that was, I think, largely what drove that was clarity of the law and ease of enforcement.
Hi, my question is for Ms. Welch. We talked in an earlier panel about a lot of times, especially where there are factory farms or contracted farms, that usually the low-wage workers don't have a lot of other opportunities for employment and maybe not holding them directly accountable. So I was wondering if we find it an effective strategy to prosecute individuals, and so I'm wondering how prosecutors' offices can be effective in the animal rights movement, and in terms of how many companies that you've prosecuted directly, and also what happens when those prosecutors' offices are also prosecuting people like Direct Action Everywhere and those violating ag-gag laws.
Okay, so that's a lot of questions. Okay, so why don't I do the last one first? I don't know of any prosecutions about ag-gag, so I can't really speak to that. In Virginia, I'm the director of the Animal Law Unit, so if one of those, we don't have an ag-gag law, but if someone brought something like that, I would strongly discourage prosecutors because of the free speech argument. But as to the first, yes, I did prosecute the actual workers. And the reason I did that was because I had them on video, you know, doing this. And I felt strongly that they needed to be held accountable, right? And because I will say, and this is one thing I left out of my presentation, I sat in a rural jurisdiction. I had a huge wildlife trafficking case. And I sat there and I watched the judge, without blinking, make a 19-year-old girl who was addicted to drugs a felon. And if we can do that, then violence to animals needs to be treated the same way. And so that's, you know, one thing that I think is important. I will tell you that there was one defendant that I took under advisement because she did not do as much as the others. And so she just, she had not worked with animals for a year, and now it's coming off of her record. So as far as I have not prosecuted a corporation in Virginia. It's very hard to prosecute a corporation, and I could not find any nexus. Like I would have to, there would have to be some notice, you know, like I'd have to know that the supervisors, you know, had told them this is what they were doing, or there had to be some kind of evidence that the corporation knew. And I did not find that. Does that answer all of them?
Yeah, thank you.
Okay.
Hi. I may be a bit unrealistic or too idealistic, but my question is, it seems that we are trying to change the way these animals live by way of making them true cage-free and not confined. But my question is that really what we want? I mean, shouldn't we go further in, I mean, killing the animal in any way is by itself something that we all know we don't want happening. We want to create a vegan world, which I know is very something, it's a goal, but the advocacy to make them cage-free in a world of increasing population, which I think it's not realistic. I think that the demand for meat and chicken, food, And in this overpopulated world, how can we feed a world if you're just advocating to make them cage-free and let them roam? It's not doable. Shouldn't we advocate for just not eating meat at all, not eating chicken at all? I think that we need to skip that step. And I know it might be unrealistic, but I don't know we're exploding. Our Earth is exploding with people.
Anybody?
Oh, was that for me? Okay. I mean, I think I talked about this in my comments, that there is an argument that these don't go far enough. And I think there was a lot in there. But, we can stand in one spot. We can stand where we are right now and say we're going to wait until we can do everything, and we're going to do nothing until we can do everything. And that's one approach. And I think that I'm an incrementalist. I worked in legislation. I think that, we've seen the change since, the first Arizona ballot, the ballot question happened in Arizona on farm animal confinement. And since the ballot question happened in California on farm animal confinement 10 years ago, but we're still seeing areas where we can't get anywhere. And so, the reason we end up at the ballot is because we can't get our state legislatures to do anything, let alone everything. And so these give us an opportunity to move forward. And as I said, it's not just about the substance of the law, it's about the people that we're educating along the way. And it's about providing those opportunities for animals to be seen for themselves, and that people even, the fact that the idea that people even should consider animals for themselves and for their own value is nothing new to us, but it's certainly a novel concept for the vast majority of our country. And so that's, I think, where these things can help to continue to move it forward. And I honestly believe, we could have an entire conference on the best and most effective ways to make change for animals and their protections and their rights the most effectively. It's been a conversation that's been going on in our movement and other social justice movements for decades, with these exact points kind of going back and forth, with each other, and no one coming down to the right answer. And I certainly don't have it, and I'm not going to pretend that I do. I can just tell you that, from what I've seen from the changes that are going to be made and from the growth that people make through these processes, it's possible that close to 6, depending on the polling in California and how many people actually show up to vote and vote yes, 6 million people in California might vote on this initiative, might vote in favor of it. That's a lot of people. And I take heart in that. And like I said, I take a lot of heart in the education that's happening through the process. And for those people, it's a start. It's a starting point. And I think that's really where we need to be. And I'll tell you, my organization, that's one of the reasons that PETA has come out in opposition to Prop 12, because they said the better approach is to engage with consumers and to continue to push veganism. And HSUS and the other groups that work on these campaigns take a multifaceted approach. It's not just the ballot questions. They're all kind of coming at this from a variety of different levels. And I think that's what we need to do to be effective, is to come at this from litigation strategies and prosecution strategies, because the laws don't matter if nobody's going to prosecute it. And so I think it's all of these pieces coming together that's going to make the difference in the whole. I don't know if that was a sufficient answer to that, sorry.
You want to go ahead? Yeah.
So I have a question for Ms. Welch. So I just thought it was really interesting how you talked about how when you were doing the case and going through all the video, you and Kelsey got kind of desensitized to it, because I feel like you don't really think about, like, you think about the factory workers getting desensitized, but you don't really think about the people who are trying to help the animals getting desensitized as well. And so I was wondering, like, in the criminal context, when you're trying to pull out, like, instances that are of, like, cruelty versus things you can't prosecute for that aren't cruel enough, like how you go about combating that kind of desensitization that might happen.
So we're transparent. So I did not plant Lila, but she was my student and my extern. So, and she's fabulous, just so you know. So hire her. No. So I think what we did, we would take a break and then go back. Initially, what happened, because I'm the boss, so I said, Kelsey, do you have time to, like, distill it down for me? So she did the first cut, and it was a lot of work. And as I told you, she is fabulous. And but then so then we had to sit down where I really looked at it with my, 20 years, hundreds of cases experience, and I was like, yeah, that's not that bad. I did the first cut. The way we got desensitized was we kept having to watch it, and like we had to watch it with the undercover. We had to talk about everything that was going on there, and just so you know, Compassion Over Killing, and I think this is why they were very effective. They were so professional, and I know I keep talking about that, but their report was as good as my experts on dogfighting, and they had laid it out so that it was painless, and so we kept having to look at these videos, and then we had to look at them with my vet, and then there were a couple that he said, no. And I was like, okay, they're gone. And so we just kept doing it, and we would take a break. And like I said, having my paralegal come over, and she's a chicken farmer, okay? So she's, salt of the earth, and having her look at it and just do it that way. Thank you, Lila.
We're getting close to being out of time, so we'll try and do a
Yes.
few more questions and then wrap up.
This will be a very quick question. In regards to the Virginia prosecution, was that facility, I'm assuming that it was a federally licensed facility, and then I'm wondering if the practice then that Tyson stopped the boning, if that was something that they were only doing in Virginia, or if that practice was instituted nationally at any slaughterhouse or facility that was working with Tyson.
So I think they are a federally licensed breeder farm. They stopped it in Virginia first, but then I think they've done away with it nationally. Like I said, it was an older farm, and I think that some of their newer operations, I got this from Compassion Over Killing, who did a lot of education of me, but the reason they had to do that was they didn't have the automated feeders, and so it is a money issue, and so, but they did stop it, and so I was really gratified about that.
Thank you.
Yeah, I have a comment, a question. My background is I'm a journalist, so I'm a proud enemy of the people. And specifically in economics and finance. And one of the things that capitalism is demand creates supply. Without demand for something, whether it's lies from the White House, whether it's a product, if there were no demand for it, the supply would not exist. So this moral atrocity is fundamentally on people who eat meat. And I wonder if by making things incrementally less god-awful, you're somehow making it seem okay for people to continue. There's still the transport truck, there is still the slaughterhouse. I would strongly recommend everyone read Gail Einitz's book, Slaughterhouse. It is simply beyond belief. Regardless of whether you make them cage-free, that's how it ends. And I think we are being way too kind to the consumer on this. So I'll just listen to your comments. Thanks.
I mean, I think it's a bit more complicated than just supply and demand. I mean, as we discussed, there are forces that artificially inflate demand, that trick people about what they're consuming. Obviously, there are various financial pressures that make access to healthy vegan food impossible for many people. So I think it is a dynamic approach that has to be taken. I do think that we need to continue to educate people, but I agree with Laura that, there's a difference between what the law can accomplish and what a social movement can accomplish. And so we can't, through the law, file a lawsuit or pass a statute that's going to abolish meat eating. What we can do is work at the margins where we can be effective and trust that people who are out in the streets, people who are pushing the message, can use that instrumentally to push the bigger question. And if you want to have a conversation with someone who still eats cage-free eggs about what's wrong with cage-free eggs, then by all means, please do. And if our case is exposing what cage-free farming really looks like, contrasted with the way it's represented in the public, I think that helps that conversation go a bit more persuasively. So yeah, I don't think it's either or, and I do think that the law has a dynamic relationship to the social movement, but it can't exist without the social movement pushing the questions of what's reasonable and how far we need to go.
I don't want to get in the way or in between people on their lunch, so we'll try and make this one as quick as we can, and then we'll wrap up.
All right, thank you. Sorry. So my question, I guess, is for Ms. Welch, but also I've prosecuted and practiced for 20 years, and I'm glad to hear your hardcore prosecutions. And maybe I'm just picking bad places, but I've worked in North Carolina, Illinois, and now Michigan, and we have the laws on the books, but nobody seems to ever do anything in any of the offices I've worked at. It seems like you have a great animal law unit. And I was just wondering, like at the beginning when you talked about the case and talked about giving the information to the Commonwealth attorney, how do you decide when a case comes either to your attention or to their attention, who's going to take the lead on that, who's going to prosecute, and why did you bring the information to the Commonwealth attorney as opposed to going through your office and prosecuting?
Okay, so that's because I don't have concurrent jurisdiction. So the federal animal law unit can go anywhere in the country, and they have power to do that. So I have to serve at the pleasure of any locally elected CA. And so the way it usually works is I'm involved with the animal control officer, and the animal control officer said, hey, do you know about Michelle Welch? She'll help you. She'll help you. And so then I call the Commonwealth's attorney and say, hey, do you want me to do this case? In my wildlife trafficking case, it was 10 defendants, 10 jurisdictions. So I went and met with each locally elected CA and asked them to let me do the case because I'd been in it from the beginning. But if it's just a regular animal abuse case or a dogfighting case, I often call in and offer my help. What I will say is, Commonwealth's attorneys and DAs are very, very busy, and they have plenty of cases, right? And so my office elevating it by creating the unit has really changed the landscape in Virginia. And I'll tell you that I have another chicken abuse case, and he called me. And so, you know, when I showed the last picture about the 820 cases, that's all about you build it, they will come. And I talked to a lot of attorney general's offices about doing a unit in their state, and I'm happy to do that for anybody who wants it.
Great. I'm supporting the current woman who's running for the Michigan Attorney General, and I'm trying to get her to start in an animal law unit. So hopefully if she wins, we can talk.
Yeah, I have a memo, so you can just give her that.
Cool, thank you.
Okay.
Okay, well, thank you all for being here.